Minister in the Ministry of Finance, you have 30 minutes.
Thank you, Mr. Vice President. Mr. Vice President, I paid close attention to the debate, and I have summed up the main objections into 3 areas. The first of which has to deal with the powers of the minister. A lot of people have expressed concerns about that. But, Mr. Vice President, what we have to be clear on is that the minister has 2 main powers that have caused concern. One is the power to appoint the board of the TTRA. Now, the implications for that is wedded to the powers of the board of the TTRA. And when you look at the powers of the board of the TTRA, the board is to be responsible for formulating, approving, and implementation of management policies only. The board is not involved at all in the administration of taxes. So we are not exposing taxpayers. We are not exposing staff members. We are dealing with management policies, things that are currently dealt with by the Minister of Finance, by the Permanent Secretary, and by the head of the 2 institutions, the Board of Inland Revenue and the Commissioner, the Controller of Customs. And what the IMF report would have clearly demonstrated is that the current functionaries responsible for the management of these institutions do not have the time to devote to the management. And this is why we have not had the progress and development and the improvement that we require. And this is why, and you can see that clearly when you look at the 4 suggestions that they put forward to improve the performance of the tax administration, which I will deal with in a bit. So the board is responsible for approving policy, management policy in terms of performance, finance, HR, the strategic plan, the budget, the annual report, and internal audit. They are not involved in tax administration, as I said. So what is the challenge with us giving to the minister the power to appoint an entity that is responsible only for management policies? In my view, there is none. We have clearly indicated the composition of the board. What we are trying to do is get a broad cross-section of people who can contribute to the development and sustainment of an organization that will be robust and can work properly going forward to ensure proper collection of the taxes and administration of the taxes of Trinidad and Tobago. That is critical. What this will do is relieve the person who is in charge of tax administration to get on with the work of tax administration, because that is the only thing that person will have to focus on. At the moment, the chairman of the Board of Inland Revenue and the controller of customs are concerned and have to deal with accommodation, remuneration, staff, making payments at the end of the month, if the air condition breaks down. All of those things now fall under the persons who lead the Board of Inland Revenue and the Customs and Excise Division, which significantly erodes the time that they can devote to the technical aspect of their job. We need somebody completely focused on collection of taxes, protection of the borders, collection of duties and excise. That is what we need. So we are dividing the powers between technical, which has to do with collection of taxes and so on, and administrative, which the board will handle. And it is only when we do that that we can have people properly focus on what they're required to do and therefore better able to do those jobs. The legislation makes it clear that neither the minister nor the board can get involved and interfere with the operation of the entities. The section 18, I believe it is, completely excludes the board from having access to information on taxpayers. It denies the board the opportunity or the authority to give specific directions to the Director General or to any employees. It denies the board access to information or documents on any legal action brought against the TTRA. So it is clear that we have made every attempt to ensure that we minimize opportunity for interference in the tax affairs of the citizens of Trinidad and Tobago. And in that view, in that regard, I think that the legislation clearly sets up that dichotomy, clearly creates the safeguards that we need, and in the circumstances, I think it is reasonable to have the minister appoint the board. The existing provisions, as I said, limit the access, protect the taxpayer, protect the Director General, and protects the employees. The second power that the minister has is appointment of the Director General. And one can say, well, the Director General is in charge of the taxes, and therefore the minister will have undue influence, which is why we have put in the provision that says that that appointment is subject to affirmative resolution. Now, I am sure if you ask the majority of people in Trinidad and Tobago who the controller of customs is, who the chairman of the Board of Inland Revenue is, most of them will not be able to tell you who that is. And therefore, most of them will not be able to confirm that this is a person with some backbone who can stand up to a minister who's trying to get problems, because they don't know. Everybody in Trinidad and Tobago knows who the Commissioner of Police is, because his appointment comes through a process in the Parliament. It is rigorously debated, and by the end of that, you have a clear sense of the person that you're dealing with, the mettle of the individual you appointed to this position. We are seeking to give the same protection to the Director General, and this is why not only we have said that his appointment or her appointment is subject to affirmative resolution. Senator Mark, who as usual was more focused on theatrics and facts, indicated to us that we are threatening the job security of the members of staff of the Board of Inland Revenue. There's no job security, everyone will lose their jobs and have to reapply, there will be a redesignation of positions. Now, that cannot be further from the truth. Either Senator Mark is still living in 2009, when the plan was in fact to terminate everybody and have them reapply, and/or he hasn't read the bill, and/or he didn't pay attention to the discussions in the Joint Select Committee. But it is clear from Section 18 that this legislation protects all employees at the Board of Inland Revenue and Customs and Excise. It clearly gives the choice to the individual whether, if he wishes to retire, he can do so. If the individual prefers the apparent greater security of tenure that will exist in staying in the public service, he can choose to stay in the public service. If he wishes to move to an organization that will be dynamic and progressive and responsive and reward him on the basis of merit rather than seniority, he can choose to join the TTRA. The choice is completely his. Nobody's position will be terminated as a result of the creation of the TTRA. So the creation of the TTRA will allow for the introduction of robust work rules. It will allow for the introduction of better customer service, which everybody who has dealt with these organizations complains about. It will deal with improved training, and this will address an issue raised by both Senator Haynes and Senator Diosaran on if you're taking over to the TTRA people who are currently underperforming apparently in the current establishment, how do you expect change? When I joined the Board of Inland Revenue ages ago, the Board of Inland Revenue at that time had the best tax training system in the Caribbean. People used to come from through the islands to attend that training. That training has been abandoned. And the plan would be, of course, to reintroduce a proper, robust training. So even the people who may be underperforming now, and there are a variety of reasons why that is happening, will be properly trained, and so you will stop having things like inconsistent responses to questions. Because like, if you call the Board of Inland Revenue now to ask them about a tax matter, you may get different questions depending on who you call. We have to ensure consistency, we have to ensure evenness of policy and so on, and we have designed systems to deal with that. Issues that will also be addressed by the TTRA, remuneration. We lose a lot of good officers from the TTRA because the remuneration is determined by the Public Service Commission, which is on a broad brush, takes a broad brush approach to remuneration in the public service and does not recognize the special skills that may be required in an organization such as that. So we have guaranteed in the legislation that people will be their remuneration will be no less favorable than it is now, but the hope and the intention is that we will improve the remuneration to properly reward people for proper service. Senator Diona Ryan talked about change management. And what I would like to assure Senator Diona Ryan is that in moving towards implementation of a TTRA, we have put together a very robust and very competent implementation team. And among the special skills on that team is change management. In fact, I would say that we have the change management expert as part of that team, and we are carefully managing that process. We have started to have conversations with the organization in terms of change management, but that has been slow because of the uncertainty of where we were going with the legislation. So once this is passed, we will ramp up all that activity to ensure a smooth process. The other issue that has been raised is why a TTRA? Why not one of the other recommendations raised by the IMF? Now, in 2016, the IMF stated that we clearly need to improve our revenue collection. And to do that, they put forward 4 options. One, and this was ranked in order of preference. The first one, establishment of a revenue authority. The second one, the creation of a ministry for revenue. The third one, the creation of the position of PS for revenue, permanent secretary for revenue. And 4, enhancing the existing system. So when you look at the order of those recommendations, you will see that the revenue authority is above, and 3 of those recommendations, including the establishment of the revenue authority, including the creation of separate ministry, including the appointment of a separate PS, is in recognition of the fact that the current system, where you have functionaries responsible for several issues, is not working. We need a specialist organization solely focused on the work of revenue. And even in that specialist organization that is solely focused on the work of revenue collection and border protection, you need to separate management responsibility from technical responsibility. And this is what the TTRA does. No other recommendation does that. When CARTAC came to us to review the IMS report in 2016, it urged us to pursue the establishment of a revenue authority. But recognizing that politics may have got in the way, it said, in the absence of a revenue authority, these other options can be pursued, but we urge the creation of a revenue authority. And if I can quote from that report, Madam President, the CARTAC said, or the IMF in 2016 said, substantial problems in revenue administration have long been recognized. For close to 2 decades, possible reforms have been contemplated because the Customs and Excise Division and the Inland Revenue Division struggled to properly function. An inability to recruit, retain, and compensate staff appropriately has resulted in a perennially high number of vacant positions. Inadequate operating budgets, exacerbated problems, and allegations of extensive corruption have dogged the organizations. These comments made by CARTAC/IMF are not new. They are issues that were recognized as far back as 2002 when Gordon Dean and his committee started their work and issued their report. And since I mentioned 2002, let me respond to comments that were made by Senators Mark and Obika in respect of my comments in 2002 to the introduction of the Revenue Authority, where they said, I'm against the Revenue Authority and I'm being forced to support the TTRA at this point. What I said in 2002 was that jumping to a Revenue Authority should not be the first option. Let's try to improve what we have. And the board and the government, in fact, listened to that. And they have been trying to improve what we have. I have with me 2 of the strategic plans that were put forward by the Board of Inland Revenue and accepted by the government. There was one in 2005 to 2008, one in 2012 to 2016, and there were others. These are just the 2 I have. Since that 2002 report, the board has introduced several strategies to try to improve its operations. There was an HR staffing plan. There was a plan to reduce the tax gap by 10%. There was a setup of a compliance monitoring unit, the strengthening of the division's internal and external investigative capacity, the launch of the CTIU in 2004. They re-engineered business processes to increase productivity and efficiency. They established strategic management teams to facilitate strategic planning. They developed and implemented systems for scheduling, and so on, throughout the period from 2002. Have we seen a significant improvement in the Board of Inland Revenue? I would argue not. As somebody who worked at the Board of Inland Revenue and then worked in the private sector, interacting with the Board of Inland Revenue almost on a daily basis, I can tell you that rather than seeing improvements, you have seen declines in performance. We moved from a VAT system which worked very well in 1990, but is not working so well now. So the attempts have been made to improve the system as is. They have not worked. We can no longer wait. We have to fix it, and we have to fix it now. And the way to fix it, my submission is through the introduction of a Revenue Authority. So the TTRA may only be one of the options suggested by the IMF, but in my respectful view, it is the only viable option, and I urge you to support it. Madam President, what our TTRA will do is create a single-purpose agency that can focus its efforts on the single task. As an autonomous organization, it can arrange its affairs in a more business-like manner, free from political interference in its day-to-day operations. And without the hindrances of the public service system, it can recruit, retain, discipline, motivate, and remunerate staff for a higher level of performance. This is what we are seeking to do, Madam President, and this is what we think we can do through the TTRA. As Senator Vera indicated during his submission, if COVID-19 has taught us nothing, it is that the state, and even those members of the state who traditionally say, well, I don't need the government for anything, I don't benefit from the collection of taxes. Every member of society in some form or fashion is now stepping forward to the government and say, you need to provide this for me. You need not only to let me go back out to work, but I cannot pay my employees while they're home because I'm earning no income. I can't pay my rent. My interest payments are too high. I need relief to ensure that my business continues. I need tax relief. I need more direct relief. And the government is working on all of these things. But the government cannot provide that support to all members of society when the government itself is out of funds. The opposition is telling us, do not take money from the Heritage and Stabilization Fund. Do not borrow because we are overstretched. Do not raise taxes because people are already overburdened, but provide relief to everybody in Trinidad and Tobago who needs it. How can we do that? I don't know if the opposition has the formula to grow money on trees, but the government doesn't have it. The only way we can do it, can raise funds, is to sell assets, this is not a good time to do that, or to raise taxes. And don't you think it unfair to say to people who have been working and paying their taxes all of these decades, that we are taking this little bit of money and we can only give you so much, like we can only give you $1,500, because we don't only have to take care of you, but we have to take care of the masses of people who have not been contributing to the coffers over the years. We have to improve the collection of taxes, so at any time that the state is required to do what it's doing now and step in and help everybody, we have the wherewithal to do that. Everybody is now demanding of government, you need to step up to the plate and support the economy. You need to support us. You need to ensure that our children don't starve. You need to ensure that you educate our children while we're at home. You need to ensure that I continue to get a salary. How can the government do that without a robust system of revenue collection? We need to ensure that we have that. At the end of the COVID period, and Senator Haynes again was talking about, we should now be focused on getting the economy back on stream and putting people back to work and the help that businesses need to continue. Yes, but unlike the UNC, apparently the government can't walk and chew at the same time. So we are doing that, but we also have to focus on what happens after COVID with this increased debt that will be on our plates, with increased debt payments, with continuing support that will be needed by all sorts of businesses in the medium term, because even when we go back to work, businesses will have struggled and will continue to need support. We have to finance that. So we have to fix our revenue system, and we have to fix it now. So what is it? There was a question about performance of revenue authorities, and I'm happy that Senator Vera again commented on the results realized by some revenue authorities. What I looked at is the revenue authorities that are closest to what Trinidad is likely to be compared to. Those are the revenue authorities within the Caribbean. There's a report put out periodically called the Revenue Statistics in Latin America and the Caribbean. In the 2017 report, which is the most recent I could find, the results, I looked at the results of the 4 Caribbean countries that are included in that report: Barbados, Jamaica, Guyana, and Trinidad. Of those 4, Trinidad and Tobago is the only one that does not have a revenue authority. All of the others have been performing better than Trinidad and Tobago when you look at their percentage of tax collection to GDP. Barbados was at 31.8%, Jamaica 27.3%, Guyana 26.2%, and Trinidad and Tobago 22.2%. We are at the bottom of the scale, having been regarded for a long time as being the country with the best economy among those. We have the worst tax collection record. I also was fortunate enough to receive from the current Commissioner General in the Guyana Revenue Authority feedback on his performance since he has been there. And what he has said to me is that in the last 3 years, or in the first 3 years of his operation, which started in 2016, he has managed to increase revenue under the Revenue Authority by 60%, 60. He went from $151 billion Guyanese dollars in 2016 to $171 billion in 2017, to $198 billion in 2018, to $225 billion in 2019. This is a Revenue Authority. When I compare our statistics, our jumps have been way below that, maximum a 2% increase. And for the last several years, it has been going downwards. So we need to do something. And we have examples of people in the Caribbean who have done something, who have introduced the Revenue Authority.
Minister, you have 5 more minutes.
Thank you, Madam President. And they are reaping the benefits of having introduced the Revenue Authority. Now, he explains, this is the Commissioner General in Guyana, he explains that the reason why he has had this success in the generation of additional revenue is that he employs what he calls a 360 system. He uses all the information coming in from all the various units under him to ensure that by the end of the year, people collect their taxes. So let me give you an example of that in Trinidad context. You have somebody who is coming into Trinidad importing a huge piece of equipment, and he declares a particular value for the commissioner, the controller of accounts, because he wants to pay a little duty. And then he goes to Inland Revenue and he wants to get a huge wear and tear allowance, so he submits a completely different value. At the moment, there's no way to link those two. Under TTRA, you can link those two and ensure consistency. I know of a businessman, foreign company, that came in and declared the value on an asset that they brought into Trinidad at $1, and then went to Inland Revenue and said the value for tax purposes is hundreds of billions of US dollars. Inconsistency, and we can't fight it now. So we need to change the way we do things, and the way we change the way we do things is to merge the two entities under a Revenue Authority and improve what we do. Now, we have mentioned before the tax gap as identified by Professor Theodore of approximately $12 billion, and the VAT gap as identified by the IMF at $2 billion. So $14 billion minimum tax gap. This is money that is out there to be collected based on activity, not money that's assessed. What we have not mentioned is that the Board of Inland Revenue, in its annual performance report in both 2018 and 2019, declared tax arrears of $11 billion. These are taxes assessed and for whatever reason not yet collected. So there is $11 billion out there to be collected. Some of it undoubtedly is under query because it's before the objection section, before the tax appeal, but it is out there. And in a country that is bleeding for money, that is overextended in terms of debt and getting more and more so, we need to ensure that the money that is out there to be collected is collected. So, as I said, we have to change how we operate, and we have to change that now. Senator Richards asked a question about implementation and that kind of thing. And as I indicated previously, we have a really solid implementation team. We have been meeting with members of the Board of Inland Revenue and Customs. We went around the country to do that. We slowed down again because the matter was referred to Joint Select, but we are going to ramp up again. We have the draft organization plan for presentation to the cabinet approval first, and then to the board, to the members of the board, so that they will know what their options are, know what they're making a decision on, and they have 3 months to make that decision. We have reviewed all the processes and updated them and improved them. So we are ready to go. All we need is for this chamber and the other one to say, let's go ahead. We can be no worse off than we currently are, and we need to be much better off. Trinidad and Tobago is at a very precarious point, and if we do not act now and act in the right way, things are only going to get worse. So I urge the members of this chamber to support this measure. It is for the benefit of all of Trinidad and Tobago. We have to put politics aside and do the right thing. I urge you to support it. I look forward to your support. I would love to get unanimous support in this House. I thank you, Madam President, and I beg to move.
Honourable Senators, the question is that a bill entitled An Act to Establish a Trinidad and Tobago Revenue Authority and for Related Matters be read a second time. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
A bill entitled An Act to Establish the Trinidad and Tobago Revenue Authority and for Related Matters.
Minister in the Ministry of Finance.
Madam President, in accordance with Standing Order 61-1, I beg to move that a bill entitled An Act to Establish the Trinidad and Tobago Revenue Authority and for Related Matters be committed to a committee of the whole Senate forthwith to be considered closed by date.
Honourable Senators, the question is that a bill entitled An Act to Establish the Trinidad and Tobago Revenue Authority and for Related Matters be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause. Okay, you sure? Mm-hmm. Minister, you ready? Honourable Senators, I will remind everyone that there are 42 clauses in this bill, a schedule and a preamble, and we are about to start the committee deliberations.
Clauses 1 to 4.
The question is that clauses 1 to 4 stand part of the bill. The question is that clauses 1 to 4 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 to 4 now stand part of the bill.
Clauses 5 and 6.
The question is that clauses 5 and 6 stand part of the bill. The question is that clauses 5 and 6 now stand part of the bill. Those in favour say aye. Aye. Those against say no. No. I think the ayes have it. Clauses 5 to 6 now stand part of the bill.
Clauses 7 to 12.
The question is that clauses 7 to 12 stand part of the bill.
Madam President, there was a question that I had about the Section 2, Clause 7, Section 2H, composition, in terms of the board, composition of the board. I had asked, and I know other people had also asked, the two other persons being there so vague, whether the minister would consider being more definitive as to who these two other persons should be.
Minister.
Yes, Madam President, thank you. Senator, yes, we did hear that question. What we tried to do in coming up with the composition of the board was find a board, create an entity that was represented by all the relevant sectors. But we also want an entity that is flexible enough to cater for change and development. So today we might find that with the world going digital like we have to accommodate social distancing, that the skill we want on the board is ICT. And so in this, we have the flexibility to do that. It may be that in a year's time, the skill that may be needed is something else. So we do want to ensure that while all the relevant sectors are represented, which I think we have covered, that we also allow ourselves the flexibility to ensure that the organization remains agile enough to continue to operate the way it needs to.
Attorney General.
Madam Chair, thank you. I thank the Honourable Senator. Madam Chair, the proposals for the amendment to Clause 7 were driven by ICAT and CBTT and AmCham's submissions. They form part of the record of the Joint Select Committee's work. That is combined with the fact that we are looking also at legislation allowing itself to be constantly speaking. The experience that we've had as a parliament is that when the law is too prescriptive as to the qualifications, you may find yourself stultified. And therefore, we would have to move an act of parliament to amend the law to look at the categories. The specific recommendations, if you look to section 7.2, and the identification of attorney at law, chartered or certified accountant, etc., those were the bare base points. The recommendations coming at the Joint Select Committee really included the fact that business sector, quote unquote, the man on the street, quote unquote, the self-employed, quote unquote, the informal sectors, those were too broad in description to put in by way of recommendation. And then there is also the risk of litigation in respect of what it means. So this general structure was taken as a combined solution to allow us the method to A, have the law continuously speak, B, allow for the involvement of categories of persons who from time to time may be representative of the state and condition of Trinidad and Tobago, C, to avoid the need for specific legislation to amend the clause, and D, to avoid litigation as to the meaning as to what this happens. I'll give you an example. You'll see it in the trade union sector when you say an entity that is representative of the trade union sector. If you look to the NCC board, where there's been litigation as to who is representative of mass players, they sound simple at this stage, but we end up in very expensive litigation as taxpayers to decide upon who should be represented or not. Thank you, Madam Chair.
So, Honourable Senators, the question is that clauses 7 to 12 now stand part of the bill. Those in favour say aye. Aye. Those against say no. No. I think the ayes have it. Clauses 7 to 12 now stand part of the bill.
Clauses 13 to 17.
The question is that clauses 13 to 17 stand part of the bill. Senator Hussain.
Thank you very much, Madam President. Madam President, during the course of the debate, I heard that the appointment of the Director General is somewhat similar to that of the Commissioner of Police in terms of the appointment having to come to the Parliament. I want to find out whether or not the selection criteria for the individual or the candidates to be Director General, whether or not it is as prescriptive and rigorous as that of the appointment of a Commissioner of Police.
So you're dealing with clause 13, is that it? Yes? Attorney General?
Thank you, Madam Chair. The reference to the similarity with the Commission of Police methodology is insofar as a session of Parliament is required for affirmative resolution. In the Commission of Police arrangements, the Constitution itself provided for selection criterion to be put out by way of orders. The equivalent of the selection criterion is effectively the statute in this instance, in section 13. When we look to the structure of affirmative resolution, we have that placed there, and then we deal with the criterion being in subclause 2, having persons who have demonstrated skill, experience in such areas, and it's set out. And then the disqualification criterion in subsection 3. So the criterion are set out in the statute. Again, this received widespread consideration amongst the stakeholders, and all of the very many stakeholders that considered this position were warmed by the route of having the Parliament approve specifically the individual by way of affirmative resolution, both by way of appointment and also by way of removal. So the answer in summary, selection criterion are set out in the statute itself in sections 13, 2 and 3.
Senator Hussain?
Clarity, Madam President. Is it that Cabinet will approve the candidate and then that candidate comes to the Parliament for approval through affirmative resolution?
Madam Speaker, Madam President, Madam Chair, that is in fact correct. Section 13.1, the Minister shall by notification, subject to affirmative resolution, appoint the Director. So the recommendation does come from the Cabinet, but the scrutiny, the very wide and careful public scrutiny happens in the Parliament.
Honourable Senators, the question is that clauses 13 to 17 now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clauses 13 to 17 now stand part of the bill.
Clauses 18 to 22.
The question is that clauses 18 to 22 stand part of the bill. Senator Diana Ryan.
Thank you, Madam Chair. Just for clarification one more time, I just need reassurance from the Honourable Minister. Could you just explain to us one more time what would happen to an employee who cannot get approval or reach an agreement with Service Commission, and if there is no substantive post existing in the public service for that person?
Is it clause 18?
Yes, clause
Yes.
18, part 2, Madam President, Madam Chair.
Minister?
Yes, Madam President. Madam President, what the provision seeks to do is to give the option to the public servants currently employed at the organizations to decide their fate following the introduction of the TTRA. So that you are asking about somebody who doesn't, I missed part of the question with non-approval of the CPO.
Right.
Approval for?
So if an employee cannot reach an agreement with the Service Commission about the post that they are going to take, or is it that the Service Commission is going to place the individual if a substantive post does not exist in the TTRA?
Okay, yes. So the Service Commission is responsible for identifying the posts that exist in the public service that are in line with the qualifications and experience of the employees who choose to remain in the public service. So that is the extent. So the Service Commission, that is their role, and we have already commissioned them to start looking at that, and to look at that in a broad perspective. So it is not that somebody who is an auditor at the Board of Inland Revenue must necessarily be an auditor in another organization. He or she may be an accountant, work in the finance unit, work. So there we need to ensure that it is widely interpreted, and this is what we have instructed the Service Commission to do. so that the person who chooses to remain there will be given a series of options in terms of what positions are commensurate with his qualifications and experience, and said, okay, these are the options that are available to you if you choose to stay in the public service.
Attorney General, you wanted to add something?
Yes, please. Madam Speaker, I thank the Honourable Member for the question. Clause 18 has, first of all, significant precedence in a number of pieces of law. We can reflect upon the Regional Health Authorities Act, the Trinidad and Tobago Housing Corporation Act, the Telecommunications Act, and the Civil Aviation Act. The formula that is set out in Clause 18 as to the three options available has in fact been tested right up to the Privy Council as well. And this formula always stands on the back that recognized majority unions, which in this instance do exist in this case, have the benefit of their workers, their members, always at hand. There could not be a situation where people are going to be put in a disadvantageous position from that which they enjoy at present. There's been constant discussion between the government and the representative unions and the workers, but the particular formula that is used here has been applied in Trinidad on many occasions, including the postal service arrangements that we did in the TT Post arrangement, and I'm referring there to the case of Martha Perch, which went right up to the Privy Council. The point is that the formula here, A, has been tried and tested, B, is one which withstands scrutiny, C, stands on top of collective agreements, and one cannot go into causing a detrimental position with respect to the rights and entitlements that have been negotiated by the collective agreements that prevail in these circumstances for public work, public services, members, etc. So we're quite comfortable that this formula works in the round.
Senator Dana Ryan.
Thank you, Madam Chair. Thank you, Attorney General. Now, I understand what both the Minister and the Attorney General is saying. I have one follow-up question. What is going to happen? Oh, first of all, have you all done a mapping exercise already to see the level of training that would be required in the Revenue Authority for the new staff? Because you're talking about an agile environment where you need robust project monitoring and evaluation and so on. Have you all already started a training exercise or a plan to train individuals because there would be a skills gap that would be existing?
The number of people that we will need, and we have also identified the positions and the skills that we will need. We haven't yet started training because in the absence of legislation, we can't commence the real serious work in respect of the Revenue Authority. But the training is something that we have mapped out, and we have confirmed that more people will be required in the new organization than currently exist on the establishment of the old. So we can take everybody and still have room for new skills, and we do have a training program that is on the agenda.
Madam Chair, if you allow me one more question. You said that you already identified the amount of individuals that would be required in the TTRA.
Yes.
Would you be able to disclose that number for us?
I don't have the exact number, but I think it's somewhere in the region of about 2,000.
Okay, so you may very well end up having to hire persons from outside
We
as well.
We expect to have to hire people because of the combination of options available to the employees and because of the size and agility of the organization we're trying to create.
Okay.
Senator Hussain.
Can the Minister then indicate how many persons are expected to transfer from the public service into the TTRA?
We have no way of knowing that until the employees start to exercise their options,
how many
or at least give an indication of how many they expect, how many expect to come across.
And how many on the establishment currently in Inland Revenue Division and Customs and Excise?
I believe it's in the region of 1,600, because although their establishments are relatively large, they are only, on average, about 50% currently staffed.
50% staffed?
On average.
Honourable Senators, the question is that clauses 18 to 22 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clauses 18 to 22 now stand part of the bill.
Clauses 23 to 29.
The question is that clauses 23 to 29 stand part of the bill.
Madam President, Madam Chair, sorry.
Senator Dillon Remy.
The clause 26, all public monies collected by the Director General of the Revenues Law shall be paid into the exchequer account at times, and 27, no, yes, 27(1), 27(2), notwithstanding Section 2 of the Exchequer Act, the Director General shall be a receiver of revenues for the purpose of this Act. Attorney General, with respect to the THA Act, Clause 49, or Section 49(1), that says, notwithstanding Section 13 of the Exchequer Order Act, all revenues collected in Tobago on behalf of the government and payable hereto in respect of activities undertaken or discharged in Tobago shall be paid into the fund. And Part 2 says, upon coming in force of this Act, any company, financial institution, etc., shall pay it in Tobago all taxes, fees, Is there any contradiction to the THA Act and what is being offered here now?
I thank the honourable member for the question. There are a number of laws that are going to have some surgery done to them. The Customs Act, the Immigration Act in certain aspects, the Board of Inland Revenue structures, the Income Tax Act, and in fact, if you look to the schedule of legislation set out in the Schedule 1, those several pieces of legislation, there are still amendments to be done in relation to that. What this bill does is it creates an entity for the management of certain laws, but those other laws need to be attended to. I want to point the honourable senator to Clause 6, subsection 2, which says, for the purposes of subsection 1C, a statutory or other body may, by way of memorandum of understanding, authorize the authority to act as its agent with respect to the collection of public monies. It is that particular subsection that allows us the opportunity to marry the THA position with this particular piece of law. That's the first part. Secondly, we have an active work product in a Joint Select Committee right now, which is the Tobago autonomy legislation, which causes a reflection for amendment of the Constitution and also several pieces of law, including the THA Act. So the intention is to preserve the autonomy aspects, not to intrude upon the THA per se, but to continue with the revenue management of Trinidad and Tobago in the current state and condition. What this law does in a very narrow sense is to create this superstructure, to plug it into the existing laws. The mischief that we're addressing is the inefficiency of the current system. The current system does not appear to be mined and managed in the way that is most efficient for our country. So what we're doing is we're creating this superstructure, we're plugging it into several laws, including laws that are not necessarily referred to in the schedule, because the schedule are the laws that are going to be run by the entity. You notice the THA Act is not there, because we couldn't interfere with that. We'd have to treat with the Constitution and the THA itself. The Section 6, subsection 2, allows the MOU arrangements with the THA so that we can comply with the Exchequer and Audit Act and consolidate funds, because remember the THA Act gives us the arrangements for the percentages back to Tobago. So whilst this government meets the 2% plus of the annual budget across the Tobago and then supplements that by way of individual ministry aspects, we're not intending to intrude on any of that or indeed amend the law in relation to that, but we've got to factor consequential amendments still to come, the Tobago autonomy structures, which we have in a joint select committee, which contemplates amendment to the Constitution and the TTRA Act. And lastly, the whole of government arrangement. This bill is intended to facilitate whole of government revenue management as we digitize and then as we consolidate accounts across the country. I know it's a bit of a long answer. I hope I've given you what you're looking for.
Senator Sipasad.
Thank you, Madam President. Madam President, in section 23G, it says the making and maintenance of investments of the authority. Could the Minister explain what is contemplated by investments? Because I thought all the funds are supposed to be deposited with the Exchequer.
We need to separate the concept of the revenue that is going to be raised by the Revenue Authority and paid into the Exchequer account, because that is being raised on behalf of the Minister of Finance, from the finances of the authority itself. The authority will get funds by subvention from the central government, and it also has some authority to raise its own funds, to earn its own funds. Minister Rambarat earlier would have talked about areas in his ministry where collection is not where it should be. One of the things that the authority can do is offer its collection services when it gets to the right level of performance to other ministries, and therefore earn fees. So if at any time they have surplus fees, rather than having them sitting down in a bank account, they can invest it to generate more money.
Okay, thank you.
Senator Deonarine.
Thank you, Madam Chair. I have several comments that I want to make on clauses 24, 25, and 28. So I will just start with clause 24 first. Is there a possibility, Minister, to introduce some sort of limit in clause 24 in terms of the power to borrow?
In terms of what, sorry?
The power to borrow, the amount of borrowing that could take place by the statutory authority.
Well, the Minister of Finance will have to approve any borrowing that the authority undertakes. And in doing that, the Minister of Finance looks at the whole picture of the government's obligations. We have this power scattered throughout the public service where different entities are allowed to borrow, but that is controlled by the Minister of Finance, who looks at the whole picture.
Attorney General.
Madam Chair, the limitation on the power to borrow exists in other laws. The guarantee of loans, for instance, etc. So there are a number of other laws which circumscribe the ceiling limits for borrowings in the whole of government arrangements. So firstly, the Minister of Finance is the filter in the capacity as Treasury under the law and the Exchequer and Audit Act. Minister of Finance acts as Treasury. Two, other laws articulate with this, in particular in relation to the ceiling limits for borrowings and positions. And there's a division in the Ministry of Finance, the debt management unit, that manages that position and keeps a careful watch as to whether we are in limits or not. The Honourable Member will recall vividly in this session, that we've in fact adjusted the ceiling limits for Trinidad and Tobago. It's happened from time to time in respect of companies, guarantees, etc. So there are several laws that articulate with this, and it will never be a position where the debt management division of the Ministry of Finance is not keeping a careful watch. Why? Because we are always looking at the risk of cross-default. If we go into positions of cross-default from a debt management structure, Trinidad and Tobago can be put on the run, and I'm speaking run in terms of a financial run on an institution. So the other laws capture that aspect.
Senator Deonarine.
Thank you, Madam Chair. Thank you, Attorney General. No, I just want to say that we need to keep a watchful eye on it. I know that there's a debt management unit existing that monitoring that, but right now we have a situation where...
Senator Deonarine, if I may be permitted to interrupt here, while we allow for discussions when we are in the committee, we also don't want to go back into the stage of debating the bill. So we are now dealing with specific clauses in the bill as we go through. Yeah?
Okay, thank you, Madam Chair. I am guided. I will move to clause 25. With respect to clause 25, it says that the authority may invest monies not immediately required to be expended. It didn't specifically say who has the responsibility of investing. Is it the board? It would be the board?
The section that lays out the powers of the board indicates that one of the things the board is responsible for is the management policies in terms of finance. So it would be the board.
Chair, what this does, it allows for an exception of the obligation to return unexpended monies at the end of the financial year. So the rule is if you don't expend monies during the financial year, it's returned to the consolidated fund. What this allows for is the power of investment so that it can actually be continued in a different form. Again, Treasury, Ministry of Finance, Debt Management Division, whole of government accounting comes into that full arrangement.
Okay, thank you. And I will just raise one question that I have with clause 28, Madam Chair. Now, it exempts the authority from using the Central Tenders Board Act or whatever subsequent procurement laws that may come into effect, and allows it to create its own rules that govern the conduct of the award of tenders and related matters. Could the Honorable Minister, one of the ministers, kindly indicate to us what is the justification for this clause, please?
Madam Chair, apart from this being the method by which we treat with state entities of this type, statutory authorities, the first thing is that the Central Tenders Board Act has particularly difficult situations in terms of government acquisition or procurement to look at. What this clause does is that it specifically requires a positive obligation to create procurement rules. In default of the creation of procurement rules, the Central Tenders Board Act shall apply in the interim. So there is treatment of mischief, procurement must be set, you must have rules. If you don't do the rules, the Central Tenders Board Act kicks into position. In answer directly to the question, it's the method by which we treat with all of these statutory authorities. So it's the formula that is used in law because the government procurement section is done in this methodology.
Thank you. So does this mean that when the Office of the Procurement Regulator, the new procurement law comes into effect, there would be some sort of interaction that will guide the drafting or the formation of these procurement rules?
From an administrative point of view, yes. Secondly, the Central Tenders Board Act will become a repeal and replace upon proclamation of the public procurement legislation. So in this law, you'd be reading scratch central authority, central tenders, replace with public procurement in the event that you don't have your rules done. From a whole of government structure and the administrative arrangements given by the Ministry of Finance, yes, there is an administrative management between the public procurement director, the management of that, in this case currently the Central Tenders Board, in making sure that these procurement rules are drafted such that they can survive scrutiny and public procurement in the best way possible.
Okay, thank you. I just needed to confirm that because in terms of the description of the persons identified on the board, no one there is qualified in the area of procurement, and it is critical that in drafting those rules that somebody with the procurement expertise is there to guide the drafting of the rules.
So they rely upon the expertise of the ministry itself in backing the entity, the legal department, etc. So the procurement rules come by way of outsourcing. So you have adequate structures for drafting of procurement rules, and what the government does is it engages in a consistency approach in terms of standards for procurement, because you can't have procurement wildly varying from one entity to the next. Remember, these are all subjected to the purview of the Auditor General under the constitutional arrangements. These are audited accounts pursuant to the Auditor General, and we've applied that specifically to this law.
Okay.
Senator
Madam
Hussain,
Chair,
I have to allow Senator Hussain. He has had his hand up for quite some time. Senator Hussain.
Thank you very much, Madam Chair. Madam Chair, I just want to get absolute clarification with respect to this clause 28. in terms of the exemption from the Central Tenders Board Act and then after the public procurement legislation, because you're giving the TTRA wide powers of borrowing and investing, and then you're creating an exemption from what will be the standard procurement rules across the public service for them to then create their own rules. If you can just be clear of the reason why they would not be meeting the same standards under the procurement legislation, but rather drafting their own rules to guide their procurement.
Madam Chair, we're comparing fish and fowl in that question. Investments, borrowings, etc., are not procurement in the concept of the public procurement and disposal of property or Central Tenders Board aspects. The procurement, an investment, a loan, a guarantee, a structure passes through the Ministry of Finance, where Treasury has to be managed by the Exchequer and Audit Act, the other laws that prevail in respect of that, the guarantee of loans, the positions, etc. So the management side of investments, borrowings, structures fall under a different regime. On the public procurement side, we're looking at goods and services being the subject of procurement and disposal of state assets. That's managed under the Central Tenders Board approach or the Public Procurement and Disposal of Property Act.
So the reason for creating the exemption from the standard procurement for goods and services is why? Why are you creating that exemption?
Because it's standard for the statutory authorities to do it this way. This is how it's done. If you look to every statutory authority that we brought or entity that we brought to Parliament in the last 5 years, and then the 20 years before that, this is exactly the formula that is used.
Senator Dana Ryan.
Thank you, Madam Chair. The last issue that I want to clarify is I'm going back to clause number 28, subsection 3. It says until rules are made under subsection 2, and it goes on. Could consideration be given to introducing a time frame for producing these rules? Because there's no time frame. It could very well, the board comes into effect, I think it's around 6 months. They should be able to produce the strategic plan, I believe. So what time frame is there for producing the procurement rules?
Madam Chair, the formula for the use of this type of language never refers to a time frame for a couple of reasons. Because we're treating with a mischief being managed in law. The mischief is, are you bound by procurement rules to do something within a structure that is regular and known and published? So the first thing is that no matter what, you're bound by a law. You don't produce rules, the Central Tenders Board must apply. If the Central Tenders Board is repealed upon the proclamation of the public procurement law, then the public procurement and disposal of property kicks into that. The promulgation of the own system, if we were to put a time frame, we'd be exposing the entity to the risk of suit and mandamus to do something in compliance with that time frame. And that is in the context of primary legislation. If we were to put a formula now, you may find that that may be in need of amendment from time to time by way of Act of Parliament, which is a very onerous thing. So in organizing this structure, one, we keep to the standard formula. Two, the mischief is treated by way of the application of the law as is. You must have a procurement. If you don't have one, use the Central Tenders Board or use the public procurement legislation. And number three, it avoids the mischief of people bringing claims which are not too far off from reality. I'll give you an example. We had a claim brought by an individual against the SSE, suing the SSE to produce its annual reports for the period 2010 to 2015. And the person that brought that lawsuit and succeeded was a member of the government that didn't do it. So somebody sat as a minister in a government, did not produce the reports for 5 full years, went into opposition, and then went to court and sued the present government for the work that wasn't done by the last cabinet, to the point where the judge in his reflections had to make the observation that the claim was a rather unusual claim. So it's that kind of mischief that you want to avoid. And the real mischief is to make sure that there is, in fact, a public procurement law or a Central Tenders Board regulation and rule which applies to procurement.
So, honorable senators, the question is that clauses 23 to 29 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 23 to 29 now stand part of the bill.
Clauses 30 to 35.
The question is that clauses 30 to 35 stand part of the bill. Senator Adjournment.
Thank you, Madam Chair. I have one question with respect to clause 30 when it spoke about the establishment of the strategic plan and the laying of the strategic plan as soon as it is ready in Parliament. Now, this is going to happen every 3 years, is that correct? In the event of unprecedented situations like this, like where we have a pandemic, and most likely there may have to be streamlining in the statutory authority, the TTRA that is, and that you may very well have a change in the strategic plan or the strategic direction of the Revenue Authority. What are the possibilities of that new or revised strategic plan being laid in the Parliament?
Well, the benefit of having a structure which separates from the operations the management and policy decision making of the entity means that the board can have the freedom to focus on changes in strategy and what we need to do. Why the law does not require the laying of a strategic plan within 3 years, I interpret the provision here as meaning any strategic plan that is designed needs to be laid. And so our strategic plans are designed, although they're not contemplated to be more frequently than 3 years, but as they are created, they are to be laid in Parliament.
The question is that clauses 30 to 35 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 30 to 35 now stand part of the bill.
Clauses 36 to 42.
The question is that clauses 36 to 42 stand part of the bill. The question is that clauses 36 to 42 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 36 to 42 now stand part of the bill.
The schedule.
The question is that the schedule stand part of the bill. The question is that the schedule now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The schedule now stands part of the bill.
The preamble.
The question is that the preamble to the bill be approved. The question is that the preamble to the bill now be approved. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The preamble to the bill is approved. Honourable Senators, the question is that the bill be now reported to the Senate. Those in favor say aye. Those against say no. I think the ayes have it. The bill will now be reported to the Senate.
Madam President, I wish to report that a bill entitled An Act to Establish the Trinidad and Tobago Revenue Authority and for Related Matters was considered in Committee of the Whole and approved without amendments. I now beg to move that the Senate agree with the committee's report.
Honourable Senators, the question is that this Senate agree with the committee's report on a bill entitled An Act to Establish the Trinidad and Tobago Revenue Authority and for related matters. Those in favour say aye. Those against say no. I think the ayes have it. Minister in the Ministry of Finance.
Madam President, I beg to move that a bill entitled An Act to Establish the Trinidad and Tobago Revenue Authority and for related matters be read a third time and passed.
Honourable Senators, the question is that a bill entitled An Act to Establish the Trinidad and Tobago Revenue Authority and for related matters be now read a third time and passed. Those in favour say aye. Those against say no. I think the ayes have it. This bill requires a 3/5 majority, and the clerk will therefore conduct a division. And I will allow for 3 minutes for members to come into the chamber so that the division can be conducted. It will take place at 2:34. May I just confirm that everyone who is supposed to be in the chamber is in the chamber so that we can start the division even though the 3 minutes haven't elapsed? Is there anyone we are waiting for? All right, we'll continue to wait.
Mrs. Gopi Schoon.
Yes? Hearing.
Mrs. Batiste Primus.
Yes.
Mr. Rambarat.
Yes.
Mr. Sinanan.
Yes.
Mr. Moses.
Yes.
Mr. Hussain.
Yes.
Ms. West. Yes. Mr. LaHunt.
Yes.
Ms. Cox.
Yes.
Mr. De Freitas.
Yes.
Mr. Singh.
Yes.
Mr. Cummings.
Yes.
Dr. Henry,
Yes.
Mr. Dookie,
Yes.
Mr. Young,
Yes.
Mr. Mark,
No.
Ms. Haynes,
No.
Ms. Amin,
No.
Mr. Hussein,
No.
Mr. Obika,
No.
Mr. Sobers,
No.
Mr. Richards,
Yes.
Ms. Choate,
Yes.
Mr. Vieira,
Yes.
Dr. Dial Singh,
Yes.
Dr. Dial Singh, Ms. Dionarine,
Yes.
Ms. Sipasad,
Yes.
Mr. Timal,
Yes.
Mrs. Thompson Aye,
Yes.
Dr. Dillon Remy.
Yes.
Madam President, the result of the division is as follows. 24 members voted for, 6 members voted against, and there were no abstentions.
Honorable Senators, the result of the division is as follows. 26 members voted for the bill, 6 members voted against it, and no one abstained. The bill has therefore been passed.
An act to establish the Trinidad and Tobago Revenue Authority and for related matters.
Acting Leader of Government Business.
Madam President, I beg to move that this Senate do now adjourn to Tuesday, May 5th, 2020 at 10 a.m. Madam President, the government proposes on that date to deal with the miscellaneous amendment bill, Madam President. But before that, the Administration of Justice Electronic Monitoring Amendment Bill. So to repeat, Madam President, on that date, the government proposes to deal with the Administration of Justice Electronic Monitoring Amendment Bill 2020, to be followed by the Miscellaneous Amendment Bill 2020. I thank you.
Honourable Senators, before I put the question on the adjournment, leave has been granted for 2 matters to be raised. Senator Mark.
Thank you very much. Madam President, there has clearly been a lack of testing of this population by this lame duck and outgoing PNM regime. Madam President, the question has to be asked, what will it cost to test our population? How many test kits we would need for our population of 1.4 million people? 1.4 million, I guess. Madam President, tracing is critical in this whole exercise. When we combined test kits with tracing and, of course, treating, maybe the government would have to find $1.5 billion or thereabout. But, Madam President, in order to ensure that our country can save livelihoods and lives, we have been calling on the government, the United National Congress, and the Honorable Leader of the Opposition to embark upon a ramping up of testing for weeks, but our appeals have fallen on perpetual and inevitably deaf ears. Madam President, how are we to know, how are the people to know the extent of the community spread if we do not engage in large-scale testing? We keep hearing about the second and third waves if we rush to ease up on restrictions. That clearly is understood, Madam President, but we need to pay attention to countries of similar size. We have been trapped with CAFA for several weeks until the government woke up one morning after a lot of pressure from the public and from the UNC to begin looking at its own capacity to check, to test rather, Madam President. And we are now hearing that the government is seeking to establish testing facilities at various hospitals so that they can deal with persons who are asymptomatic in our society. Madam President, laboratories have been begging in this country to assist the government. We understand about 6 of them have made the applications, but there's a question of accreditation. Who is to certify these laboratories? Is it CAFA? Is it the Ministry of Health? Who, Madam President? We are yet to know which agency is to carry out this task. So, Madam President, we have to increase our testing of the population. We are hearing about everything is, the government that is being guided by the science. The government is going to be directed by the data. Who can argue against that? However, Madam President, we need to ramp up our testing of our population. Madam President, we know that there are similar countries, the size of Trinidad and Tobago. At this time, if the government had planned properly for this outbreak, as they claim that they have planned, we should, at this time, be tested or be testing or would have tested close to 20,000 people or thereabouts, between 15 and 20,000 people. But instead, what we have the government telling the country is that we'll have 700 tests between the announcement in April to when the Prime Minister addresses the nation on the 10th of May to make a determination, Madam President. But, Madam President, in places like Iceland, with half of our population, information indicates that they have conducted over 15,000 tests thus far. Hawaii has also conducted over 15,000 tests so far. In a population of 1.4 million people, we have conducted approximately 1,000 tests, we understand, thus far. And, Madam President, this represents 0.07% of our population. This is totally unacceptable. The United States has tested some 1.6% of its population, representing, from my figures, close to 6 million people or above at this time. The situation cannot be allowed to continue, Madam President. The government needs to ramp up this testing of our population. And we cannot continue to get excuses from this administration when the lives of people are at stake. We hear the government repeatedly saying, Madam President, that they have to save lives. And we agree, we have to save lives. But Madam President, if we are to save lives in our country, we need to pay attention to what is critical in this arena. And whilst the government has said that the WHO has talked about tests, but they're only referring to people who are symptomatic, we are saying, Madam President, we cannot have our cake and eat it. This is the same government that said it didn't have to follow the WHO directives when it came to traveling. This is the same government. So, on the one hand, they did not support this question of traveling of the WHO, but here it is on the other hand, the government is not seeking to deal with this question of critical importance. That is, to get a policy and action and activity in place to deal with testing of our population. So, Madam President, our call is very simple and very straightforward. We call on the government of Trinidad and Tobago to do the proper thing, to engage in mass-scale, large-scale ramping up of testing. And we do not believe that 700 tests between now and the 15th of May will cut it. And that is why, Madam President, we have made this appeal today. We are happy that the government has moved away to some extent from CAFA, and they have gone forward with their own testing arrangement. Thank you very much, Madam President.
Minister of Health.
Thank you very much, Madam President. And I thank the member for this motion as it gives an opportunity to talk to the population through you, Madam President. Contrary to the motion brought here before this honorable chamber, the government of the Republic of Trinidad and Tobago has started community testing for COVID-19. In refuting this motion, outside of CARFA's 1,772 tests conducted as of May 1st today, I will now summarize for the benefit of those listening how this government has been proactive in preparing for and visionary in providing for the present COVID-19 pandemic by taking on bold, innovative, and measured steps to increase testing, which is led by science, and the hallmarks of science are discipline, rigor, protocols, and processes, so the outcomes can stand scrutiny. On January 10th, 2020, WHO issued a comprehensive package of technical guidance online with advice to all countries on how to detect, test, and manage potential cases. The Ministry of Health engaged PAHO and CARFA for technical advice and began a strategic response. CARFA tests all suspect cases of COVID-19, and Dr. Tedros' words have been misinterpreted even by the Honorable Kamala Prasad Bisesa, and here again today. Dr. Tedros never said, test, test, test. He never said, test all symptomatic patients, as just said. What Dr. Tedros said was test, test, test all suspected cases, isolate, and so on. Senator Mark said today, suspect cases or symptomatic. He never said that. He said test, test, test all suspect cases. Madam President, on February 7th, 2020, 27 days after the virus's genome was sequenced, Trinidad and Tobago submitted its first sample for testing. 27 days after, the genome was sequenced on January 10th. Fantastic achievement. Many other bigger countries could not do that. On March 7th, 2020, 70 post-mortem samples were tested by CARFA, and that is a form of community testing. March 7th, almost a month ago. On April 14th, 2020, testing commenced at one health center in each of the 8 counties in Trinidad and one health center in Tobago, community testing. As of today, 304 community samples have been tested, and all have come back negative. Madam Speaker, if I listen to Senator Mark, we will fall into the same trap that many countries fell into early in this pandemic, when they went out there and indiscriminately tested asymptomatic persons. What that does, Madam President, it gives the country a false sense of security because all those tests will come back negative. And we avoided that pitfall. We avoided that pitfall because testing asymptomatic people randomly, the third person on Frederick Street, will give you negative results. That was the downfall of countries which were held up as the gold standard. Madam President, I wish to reiterate the following scientific methodology for testing. And I'm so disappointed to hear the UNC castigate CARFA. You know when CARFA was given birth to? In 2012 under UNC administration, when the Honorable Kamala Prasad-Bissessar signed a heads of a government agreement to birth CARFA. It's absolutely shameful. The use of WHO's polymerase chain reaction method remains the gold standard for testing because it is 99.99% accurate. The same private labs the member wants. We were getting false negatives from private labs as early as March. Am I going to allow that to happen? You can't. Why? Because you have to set up a bio-level safety 2 lab. These things don't grow on trees. What it is that we are doing now, against the background of the unprecedented global demand for COVID-19 testing, we have operationalized a biosafety hazard level 2 lab at Eric Williams, at the Virology Laboratory, Holman Williams Building, School of Veterinary Medicine, Eric Williams. The entire process was fast-tracked from the normal period of 9 months to less than a month. That is what we did. These things don't grow on trees, with an eye on quality so that we could get the same 99.99% accuracy as CARFA. So we set up the biological safety level 2 lab. We had to procure and install specialized equipment such as the PCR system. You have to get swabs, extraction kits, primers, probes. You have to satisfy CARFA's and WHO's quality standards. And to date, community testing, 304. You have to train technicians. 82 technicians were trained. And I want the population to understand how dangerous loose talk is by the UNC. In a similar motion in the lower house, a medical doctor, no less, Dr. Tim Gopi Singh, said, we should start antibody testing like the United States. Madam Speaker, antibody testing, if you read the literature, has brought more confusion than clarity to the issue. As of now, the national discussion cannot be made on antibody testing, and this is what is being recommended to us by the UNC. We are going to be rolling out, with the same care and attention, other testing sites at San Fernando and Tobago and MRFTT. Madam Speaker, this is how you do things scientifically, deliberately, and with rigor to protect the lives of citizens of Trinidad and Tobago. Madam Speaker, every country in the early stages of this pandemic that sought to ramp up testing without clear protocols have now lived to regret it. Why? Because many of those early tests gave that country either false negatives or a false sense of security. And there's nothing worse than a false negative. Because when you test asymptomatic people, they think they are now invincible. They go out there, they attend COVID parties, get the virus, and think they are now immune from getting the virus, and then spread it throughout the country. One of the reasons that we have been spared the ravages of this pandemic, and my friend opposite refuses to admit this, is that we took decisive action from January 30th to gradually shut down our borders with China, with Iran, South Korea, Japan, England, Germany, France. We suspended the cruise ship season. Could you imagine if we had not suspended the cruise ship season and one cruise ship like the Diamond Princess docked in Port of Spain with over 700 positive COVID patients descending on Port of Spain? That would have been an unmitigated disaster. So those were the measures that we took to mitigate risk. And you move from mitigation to containment. And that is what we have done now by all these 12 public health measures, from mitigation to containment. And this government has been clear, steadfast, led by a very sober man in the persona of Dr. Keith Christopher Rowley, who has always been led by the science. That is what we have done. Madam Speaker, in closing, I want to deplore the comments made by the Honorable Kamala Persad-Bissessar, former Prime Minister, when she attacked the Chief Medical Officer, saying that he was hiding figures. Madam Speaker, that deserves an apology. No one is hiding figures, and the government has a view that this motion brought by Senator Wade Mark is of no merit, of no value, and we denounce it in the most stringent language. Thank you very much, Madam.
Senator Mark.
Thank you, Madam President. Madam President, the Honorable Kamala Persad-Bissessar, political leader of the UNC and leader of the opposition in the Parliament, have been advocating on behalf of the party and on behalf of very critical segments of the community for an early consideration as it concerns the reopening of our economy within certain stipulated guidelines and protocols, not reckless reopening, not irresponsibly, or not an irresponsible approach, I should say, to that exercise. Madam President, we have called for enhanced health, hygiene, sanitation, and occupational safety protocols. at all places of business, as well as government offices, in order to facilitate an early opening of our economy without endangering people's lives and health. Madam President, these protocols, we have argued, should be coupled with staggered working hours for different sectors, continue social distancing measures, and limit recreational activities to acceptable minimum. Madam President, in this way, people could be put back to work and allow them to earn income, allow our business community to continue to contribute to our national economy. Madam President, the government has extended the stay-at-home policy to May 15th, and the Prime Minister is expected to address the nation on May the 10th. But with our testing capacity still below international standards, hence the reason we have been calling for a simultaneous attack on two fronts as we seek to reopen our economy and put in place protocols to safeguard lives and livelihoods. We have to pay attention, Madam President, to the area that I've just outlined. Madam President, small and medium-sized businesses are hurting very seriously. They depend, like so many of us, on cash flows for their business to operate successfully. But over the last couple of weeks, many of these businesses have been under stress. Many workers, part-time, contract workers, have been placed on the breadline. And Madam President, if we do not take a bold and daring position on this particular matter, we can find ourselves and our society in a very, very dangerous situation. Our economy, already given the figures outlined by the government, is taking a severe beating in terms of revenue slippages. Madam President, we can see, because of the long delay in seeking to get things going once again, many citizens are under extreme pressures. Long lines are being formed outside banks to get their $1,500 and whatever rental support. Madam President, recently, the Trinidad and Tobago Chamber of Industry and Commerce, in an article in yesterday's newspapers, made a call for the government to consider reopening this economy a little earlier than they have planned. They have already developed what is called open and safe protocols for their members, and they are calling on the government that rather than wait until the 10th of May to announce what it is going to do on the 15th, that step ought to be taken to address the matter of reopening of our economy on an incremental and gradual basis, Madam President, to save tens of thousands of small and medium-sized businesses who, Madam President, as we speak, are having great difficulties even in meeting their monthly rental commitments to their landlords. So, Madam President, this motion that I have raised this evening is to alert the government, alert the country that we need to move quickly and swiftly with all the safeguards to begin an incremental and gradual reopening of our economy, Madam President. So this is the purpose, Madam President, of this motion. We call on the government, if it does not have a plan, we want them to borrow ours. It is available free of charge. There's a comprehensive transformational plan for recovery of our economy to deal with stabilization, to deal with the development of new industries, to create thousands of new jobs, Madam President. So we are calling on the government, if they cannot develop quickly a plan to open this economy very early, we are prepared to allow the government to use and to look at the UNC master plan for transformation of this economy. In closing, Madam President, the situation is extremely dire as it relates to small and medium-sized business operators and organizations in this country. And many, many tens of thousands of jobs are now at stake. And we need quick movements on the part of the government to address these situations facing our population. But doing it, Madam President, within the strictures, the guidelines, and the protocols that we have outlined without endangering lives and at the same time livelihoods of citizens. I thank you very much, Madam President.
Minister of Finance.
Thank you very much, Madam President. Thank you very much. I wish to state at the outset that we would not be availing ourselves of any plan prepared by the UNC with respect to this problem that we are facing at this point in time. And there's one good reason for that. The UNC's pronouncements over the last 2 months have been a bundle of contradictions. When the government of Trinidad and Tobago decided not to invoke state of emergency procedures because of the adverse consequences that would flow from that, the suspension of human rights, the imposition of a curfew, the restrictions on movement, and so on. The other side demanded a state of emergency. When this government closed our borders in order to avoid imported cases of the virus, the other side demanded that the borders be reopened and went so far as to take legal action to get borders reopened so that the virus could be imported into Trinidad and Tobago and kill people. When the government, you want a point of order?
Standing order
Which?
46-4.
I am not accusing you of anything.
No, but you imputed improper motive.
Not to you.
Minister, if you could just refine how you present your statements.
Madam President, I never said that. I said that the other side wanted us to open the borders so that the virus could be imported and the virus would kill people. So, Madam Speaker, everything the other side has said has been a contradiction. When the government decided to close places of business where people congregate, such as bars and restaurants and amusement parks and so on. Honorable members on the opposition bench demanded that rum shops be kept open. These are facts. This is on the public record. I heard the Honorable Senator Mark himself say that rum shops should be kept open. So that we are not accepting any plan produced by the opposition. And all I can say is thank God that the PNM is in government at this time. I also want to thank our healthcare workers. I want to thank those on the front line who have worked tirelessly, despite unwarranted attacks from the opposition, who have accused them of hiding data and so on. I want to thank our, Madam President, how am I going to get
Madam President, Standing Order 46. 6. We never accuse anyone except the government.
Minister, continue, please. Minister, continue. Senator Markov asked the minister to continue.
Madam President, it's a matter of public record that the leader of the opposition accused the chief medical officer of hiding data. That is a fact. The members opposite can pretend that it is not so, but it is so. So I want to put on record our respect and our admiration for all of the medical practitioners, the chief medical officer, and all of the healthcare workers, the nurses, the attendants, everybody that has ensured that we have flattened the curve, because we have done that. And it is not just PNM saying so. I'm sure honorable members would hope that this publication produced by Oxford University, where Trinidad and Tobago is number 2 in the world in terms of managing this virus, was fake. I am sure honorable members opposite would hope that it was fake. But it is not, Madam Speaker. It is not. And it is because of the very disciplined, careful approach to dealing with this deadly virus, this killer virus, this silent killer, that we have maintained the number of cases of the virus at 116 for the last several days, Madam Speaker. If you look, Madam President, if you look at the curve, it is indeed flattened. And this additional period, it's only 9 days to go before the date announced by the Honorable Prime Minister when announcements would be made with respect to gradual reopening of the economy. That is only 9 days away. And this period is simply to determine, now that it has been established, that known cases that are inside of the healthcare system, hospitals and step-down centers and so on, known cases of the virus, now that that has been controlled and that there's no more spread of the virus among imported cases who contaminated relatives and so on, the last stage that has to be looked at is whether there are unknown cases outside there in the community. And this last 9 days is to establish exactly that. And during this period, which it appears will last somewhere in the vicinity of 2 months from the beginning to the end, this government has spent and made provisions at an unprecedented level, Madam Speaker, unprecedented. $700 million in refunds have gone to businesses in cash in a matter of weeks in order to put them in funds, Madam President. Just this week on Monday, I signed an agreement with the credit unions to give them a pipeline of funds, $100 million, so that they can give loans of up to $5,000 a month for 3 months to their members. There are over 100,000 credit union members to carry them through the period of the restrictions with respect to this virus. We're in the final stages of finalizing a soft loan guarantee program for small and medium enterprises, Madam President. The government, through the Minister of Social Development, has already given out over 20,000 food cards, Madam President, valued at $65 million, Madam President. All of that done in a matter of weeks. A matter of weeks. And only on Monday and on Wednesday I answered a matter in the other place with respect to our decision as a cabinet, which was confirmed only yesterday, that we would give $10 million a month to the major religious bodies in this country to distribute food to the poor and needy. That was only confirmed by cabinet yesterday. And I can come here today and say that I've spent the entire day with my budgets division, the Treasury, the Auditor General, and the Office of the Prime Minister to ensure that the first set of payments from that $10 million facility will be made this afternoon. That is the speed this government is working at to help the poor and the needy, Madam President. So that I would ask honorable members, the majority of the population understands what we are doing. All of the opinion polls show that the majority of the population agrees with what we're doing. The majority of the population supports what we are doing. And I can assure you, Madam President, that when it is appropriate, the government will proceed with a phased opening of the economy. But we are taking advice from the experts, from the medical professionals, from the World Health Organization, from the Pan American Health Organization. We're not taking any advice from Senator Mark. I thank you, Madam President.
Honourable Senators, the question is that this Senate do now adjourn to Tuesday, May the 5th, 2020 at 10 a.m. Those in favour say aye. Those against say no. I think the ayes have it. This Senate now stands adjourned to Tuesday, May the 5th, 2020 at 10 a.m.